Hey everyone, can everybody hear me? Shout out to everybody in the chat. Let me see what I got here in the house. Welcome, good morning. Good morning, good morning, good morning, good morning. Thank you, Tazzy, for telling everybody in this house to hit the like button. Thank you, thank you, thank you. Anna, did you notice the new little channel emoji? I just replaced it with another one, and it's my confusional face. That's the confusional emoji. Every time we talk about something that's so confusing, you guys are allowed to use that and use it. All right, let me shout out to everybody. Welcome, welcome, welcome. Sandy, thank you for becoming a member, love. Welcome. Everybody, Rose, Tammy, Nebulous, SW, Dee Dee, Anna, welcome. Who else do I have in the house? Let's see. Natalie, welcome, love. Oh my gosh, you guys. Chico, I haven't even had my coffee yet, and I was like, let me just go live. I woke up a little bit late today. It's too much. My inbox was blowing up on some other stuff. Okie, let me see. Who else is in the house? Peekaboo, Spooky Paws. Dee Dee, I already said hello. Let me see who else. Who else? Clarice, Daisy, Talia, how you doing? Pay Girl, Tammy, Layla. I literally came on YouTube hoping Rabbit would be live, and Discord confirmed my hope. Aw, Layla. Shout out to Layla. She renewed her membership. Shout out to you, love. And no, if you're a member, Discord is a perk. There's everybody likes to, cut up on Discord and talk and do all kinds of stuff. Check out Discord. Check out Discord, okay? Everybody, welcome. Hey, Nicole, Liz, Grandma, Red Door Woman, welcome. Ruby, Red Lopez, welcome. Queen Bella, Wim, how you doing? Hope you're doing well. Flora's in the house. Welcome, Flora. Thank you for renewing your membership. You're awesome. Thank you, thank you, thank you. Let's see who else is in the house. I think all the members are here. Emily B, Generally Jenny, Kathy, how you doing? Welcome, welcome. Kimmy, how you doing? All right, everybody is here for the most part. Alyssa, how you doing, love? I've got words is in the house. Welcome. Excuse me. Rose with Thorn, Tina. All right, we are gonna get it together. We are going to get it together. Shout out to everybody. Shopaholic, Lori, Blonde Bomb, my beautiful, wonderful Queen Bella's in the house. All right. So we're going to talk about the Alexee Trevizo case. You guys know we've been following this case for a couple months actually, way before Law and Crime and all these court TV kind of came in, right? We've been following it. We've been talking about it. For those that don't know what the Alexee Trevizo case is, it is a girl out of New Mexico who at the time um, went to the hospital with her mom and gave birth in a bathroom and put her baby in the trash can, double knotted the linen, didn't tell anybody she was pregnant or that she had had a baby, and then went over to the emergency room. The baby passed away, died of what is it? I can't even say the word. Died of entrapment. I'm gonna say it like that. Basically, the baby suffocated in the trash. This situation happened back in January of 27. Okay. And law enforcement did their investigation as far as their interviews. Um, I think April, they started to interview the staff, the medical staff. And, we kind of came in with this idea. A lot of us were like, when we found out about this case, we're like, "Well, what is going on?" Right? Because here you have a young girl, she's 19, okay, denies having sex based on what the medical staff is saying. That she's not pregnant. Mom is in the room as well. We see the body cam footage. Mom definitely looks like she is a very much overbearing kind of mama where, you know, she's afraid of worry. She's afraid to get her mom upset, if that makes more sense, more so than what has happened and what she did, putting that baby in the trash can. The artesian community of New Mexico has been pretty upset. A lot of people have been following this case. It's been a huge social media case. We have a lot of questions, right? In the last couple of days, matter of fact, this morning, there was documentation that was submitted by uh, the state. The prosecutor has responded to the defense attorney's motions. All right. So if you guys remember, there was a request for change of venue from the defense, and there was also a request. I can't remember um, the conditions of her release. So she posted bond. Okay. And she's been able to be home or wherever her family's at. Um, and she just has to check in with whomever she has to check in to be able to do that, right? The attorney has decided to put in those conditions because Alexee is supposed to start college this year in August, right? She's supposed to go, I think, to the University of New Mexico, something like that. And from there, there were some motions that were put in. They're wanting Lexi to have contact with Deyvn, the father of this baby. Deyvn and Alexee are still together. They attended prom together. They were together. The family, Alexee's family, denies that she knew that she was pregnant, and they're standing by that. Even after she had a whole baby come out of her, they're still saying that she didn't know she was pregnant and essentially blaming the hospital. So much so that there's a uh, wrongful death lawsuit against that hospital. All right. I'm just breaking it down because there's a lot of new people that are just joining us. So I wanted to give you guys a little quick summary. So we have a whole playlist, and it's very much in the front of my YouTube channel page. A lot of people have been contacting me about this case. A lot of people have said, Rabbit, schoolmates have spoken out because this past year, well, this semester, Alexee graduated, but she didn't walk. Deyvn walked. Alexee didn't. They went to prom together. So people are confused. The community's upset about what has happened. All right. And how they're treating it like it's the hospital's fault that the baby wound up in the linen. One can make the argument that there was probably a lack of a lack of action in the hospital's part because they gave her a pregnancy test. They asked her if she was pregnant. After denying that she was pregnant, the pregnancy test came back positive. Okay, keep that in mind. They still let her go to the bathroom, locked herself there for 20 minutes, and was flushing like crazy. They were hearing these flushing sounds based on what the hospital staff was saying. And so they were concerned that she was essentially flushing something down or she was miscarrying, but she was still denying being pregnant. The baby was full term. She was taking diet pills, and then at one point was taking birth control and still denying that she was having sex. So it is a big case. It's very concerning. And it leaves us to that question of like, whoa, if a woman can do this at a hospital while she's getting medical care, like we hear about these stories happening all the time. People leave their babies in trash cans or somewhere else, or even, people, use the safe haven box, right? Which is what is meant to be there for those that don't want to have a baby of a certain time of frame, to just leave the baby there safely. This is at a hospital where essentially you're there to get treatment, right? It's what you're supposed to do. So this happens. And we have talked about this. We said, the hospital could have definitely stepped their game up a little bit. If they knew she was pregnant, she didn't have to be in that bathroom. If they knew what was going on, they didn't have to do all that, right? So why don't we start with this? Let me mute myself over here. And shout out to everybody that's coming through. Shout out to you guys. Thank you for being here. We're going to start with yes. We are going to start with the state's response to the motion to suppress. All right. We're going to start right there. Let's start with that one right there. I think it's this one. Yes. Make sure I got the right document showing up. Hold up. Yes, we're going to start right there. Now, we're going to credit some of the bloggers because some of these documentations are coming from a lot of TikTokers, but they have created essentially a hub for all of us to be able to view these documents. I have been locked out of, I don't know, pay. I gotta call some people and everything. So it's going to take me a minute to even get to that, and I just don't have that kind of time. So this is from the At the 10th Woman. Check them out. I think they're on Twitter, and I'm going to make sure I link their handle, social media handle, in the description box so you guys can check them out. Okay. Let's start with this. This is the state of New Mexico's, and let me make myself smaller. Yes, thank you. Here we go. Shout out to everybody. Talia, everybody coming through. Thank you guys for being here. State of New Mexico's response to exercise of privilege, motion to suppress, motion for protection order, and Pina versus Espinosa procedure determination comes now. The state of New Mexico, by through the district attorney, Diana Luce, and hereby requests the courts deny the defendant's above title motion to exercise privilege, suppress evidence, and for a Pina Espinosa procedure determination in the state of the following is support thereof. Statement of the facts, okay? January 26th of 2023, the defendant was admitted to the hospital shortly before midnight complaining of lower back pain. While being evaluated, defendant entered a patient's restroom alone and locked the door behind her. The defendant remained in the bathroom for an extended period of time and refused to open the door for staff who became increasingly concerned for her well-being. Hospital staff were forced to get a key from security to enter the restroom. When nursing staff entered the restroom, they were confronted by a large amount of blood. Concerned by the large amount of blood, nursing staff checked both the toilet and trash can for evidence of a pregnancy or miscarriage. The toilet and top layer of the trash can appeared to be empty upon initial inspection. When a custodian cleaned the bathroom, they noted that the trash can was inordinately heavy. As housekeeping pulled the trash can liner, the hospital staff found a newborn in the trash bag. The nurse began to administer life-supporting measures on the newborn boy, but he was already cold and blue. Now, let me stop at number 8. Okay? We have watched the interviews with the staff members. We have seen what the nurse and the doctor said. No life-saving measures were done because they did not want to disturb evidence. Do y'all remember that? We went through that. Let me know in the chat. We posted shorts on this. We definitely talked about this. Yes. There were some people that, because if you go back to the interviews, there was a medical technician that took pictures, and law enforcement didn't even know about these pictures until April when the crime happened in January. Y'all remember that? Thank you, SW. You remember no life-saving measures were done based on what the doctor said, because the doctor said they did not want to disturb a crime scene. And based on what they were seeing by touch, there was nothing to save. Baby was already gone. He'd been under there for, I think, a total of what, like 40 some plus minutes between the time that she was in the I mean, we don't know how long that baby was in the trash can there, and then the additional 20 minutes. Yeah, crazy. All right, you remember that. Okay, everybody remembers that. All right, I'm not going crazy. Let me begin. So that was number 8 that was listed as such. Emergency department physician Heather Vasquez declared the newborn dead at about 2:28 a.m. on January 27th. Given that a potential homicide involved the abandonment and the abuse of a child and occurred on hospital premises, the hospital contacted law enforcement. The attending physician advised the defendant of the discovery of the newborn and that the life-saving measures were unsuccessful, which, again, there were no life-saving measures because they did not feel like this baby was alive anymore. But hey, maybe that is a debate for the courts at this point. Sandy, you caught that? You caught that? All right. All right. Let's keep going. Everybody caught that for the most part, everybody that has been following this case. Law enforcement officers were present in the treatment room when the defendant was informed of the discovery, but asked no questions of the defendant themselves. Defendant, upon learning her baby had been discovered dead, concealed underneath an extra trash bag, the defendant explained, "I am sorry, it came out of me. I didn't know what to do." Medical staff advised the defendant of the next steps in the treatment process, and law enforcement officers advised the defendant that she was not under arrest but being detained for investigative purposes. The defendant's mother began asking for questions related to her delivery and disposal of the newborn boy, and officers asked her to not speak to her daughter about the circumstances until detectives were able to initiate their investigation. The defendant was transported to another Lovelace hospital in Roswell, New Mexico for further medical care. Interviews were conducted with medical staff who were mandated reporters in reference to the criminal investigation regarding a homicide that occurred on the hospital premises. Lord have mercy. Look, it's a lot. All right? It's a lot. Let me go up a little bit more. Okay? Number 16, for those that have not been following this case, the reason why she was transferred to another hospital, because it's my understanding that this hospital is just like an extension type of hospital. They did not have the OBGYN services because they still believed that at the time she needed to be transported to another hospital for her to be able to deliver the placenta. When we read the reports, we found out that the placenta had already been delivered, right? The cord was like removed or torn out of the placenta. I don't know how much flushing she had to do in order to flush that placenta, whether the placenta came out in pieces, but the placenta essentially was something that was separate. Now, if you've had children, you understand. I don't like, I would just imagine nobody heard her cry. Nobody heard her say anything out loud. Nobody. She delivered, right? And this was her first baby, my understanding. Now, keep in mind that the hospital had also given her medication for what they were treating, which was back pain. She was complaining of back pain. The defense is saying, hey, it was that medication that might have been labor inducing, right? Or it also might have affected whether this baby was born dead or alive. Based on the autopsy report, the baby was born alive. The baby died the minute that she double knotted and put another a bag, excuse me, on top of that liner. Thank you, SW, for the $5. They evaluated the baby to start life saving measures. Thank you. But was too far along to initiate. Baby would have been brain dead, says SW. Thank you, SW. Thank you. Yes, she was given morphine and muscle relaxers, which would then the argument would be, well, therapeutically, is that safe for mother and child? But that was again to treat the back pain. Keep that in mind. I need to get my drink because it's a lot of reading that we have to do. Give me 1 second, guys. Let me run to get my drink. All right. All right. I am back. I'm back. Thank you. Thank you. Thank you. Whew. It's a lot of reading. Okay. So in this document, of course, they make the law and argument um, statement here, paragraph. Law and argument. The defendant motion to suppress based on alleged violations of HIPAA, okay, medical records privacy provided by the ruling is there, should be denied as HIPAA allows disclosure of medical information to law enforcement under the circumstances of this case. Additionally, HIPAA violations, even if one had occurred, do not mandate suppression of evidence. Likewise, the New Mexico ruling confers no physician patient privilege with respect to communications knowingly made it in the presence of a third party. Now, let me stop right here. If you guys remember, the defense attorney was submitting what is it motions and saying that this case should be dismissed based on HIPAA because there was various HIPAA violations. Welcome to the membership, Rebecca. Shout out to you, love. Thank you for coming through. Ooh, you are so cute. Shout out to you. All right. Sorry, I saw your avatar. So motions. The defense was saying there was huge violations from HIPAA because they released body cam footage. They, stuff had been already been out there by social media. There was no way that this girl was going to get a fair trial, which is why they did the change of venue. Keep that in mind. What else? They talked about how law enforcement then released they allowed for FOIA to happen, for all of that to happen. So yeah, they were very much like, we need to dismiss this case. Defense attorneys pulling the straws, as a defense attorney would. All right. Some of you guys were upset with the defense attorney calling him Colonel Sanders. I said, listen, the man is doing his work. Let him do as he's defending his client. You would want somebody to defend you, right? That's what he's getting paid for. So yes, they were very much upset. Very much upset, right? Whoo-wee. I'm looking at the comments. Let me see. Yes, she was taken to Lovelace to the labor ward and had to have a DNC. Thank you. They still had to clean, a DNC. They have to clean everything out, make sure that to stop the bleeding and whatnot. Thank you for saying that and for fixing that. Shout out to you. Okay. Let me see what else did you guys are saying. You think Kelly? No, Kelly, you're referring to the wrongful death lawsuit. There's an additional wrongful death lawsuit that was filed for the decedent, which is the baby boy. His name is Alexee Fierro, named after mom. Last name Deyvn Fierro is the dad. Kelly says this lawsuit isn't going to fly. Now, this is the motion. That's not, this is from the state. That's not the wrongful death. That's not the civil matter. This is the criminal matter. Years and years ago, laboring moms were given morphine. It's not great for the baby, but it's not likely to cause the death of a newborn. They are reaching. They are reaching. All right. Whoever, Patricia, I spell HIPAA wrong all the time, Lord. Forgive me. I spell it wrong. I spelled it with 2 P's and 1 A. Don't come for my neck. I do. Because it's just something that I always spell. I always spell it wrong. Don't get mad at me. I promise you, I'm a good person. Juju. All right, let me stop. I try to interact with everybody because some of this is just a lot. I spell it. Listen, I might spell it hippo if it wasn't for the A at the end. All right, don't come for my neck. I do spell it wrong all the time. Shout out to you. Thank you, Emily. Thank you. All right, let's get it together. Let's get it together. Let's keep reading. So it says HIPAA does not preclude medical providers from disclosing information to law enforcement regarding the crime committed on the premises. So again, the argument as to why HIPAA would not apply. Was there a HIPAA violation once? And that was our question last time. Once it becomes a crime, does it apply to HIPAA? Like, is there HIPAA applications? When is it that HIPAA stops? The defendant argues that all medical records disclosed in violation of the privilege and/or HIPAA will to be suppressed. HIPAA is the primary federal law which was passed to ensure that an individual's right to privacy over medical records. It governs the confidentiality of medical records and regulates how and under what circumstances covered entities may use or disclose protective health information about an individual. The term cover entities is defined to include healthcare plans, healthcare clearinghouses, and healthcare providers. Protected health information includes all individuals' identifiable health information maintained or transmitted in any form, as well as any oral statement made about medical treatment or conditions. Generally, HIPAA prohibits the use and disclosures of an individual protected health information unless, ooh, you gotta love that unless. I took the LSAT once. I need to retake it again. Maybe one day I'll go. I can't. I put the law school stuff behind me until baby bunny. She's got to get a little bit older. But I know words like unless is a huge word. Unless the individual has authorized its use and disclosure. HIPAA provides, however, that a covered entity may use or disclose protective health information without the written authorization of the individual or the opportunity for the individual to agree or object in certain limited circumstances. One of those exceptions is where a law enforcement official seeks protected health information for a law enforcement purpose. This sounds like a very much a law enforcement type of purpose. Just saying. This is a law enforcement type of purpose, right? I mean, you think it's Cape is like this is reaching? It is ridiculous. All right. I'm reading some of the stuff that you guys are saying. Lord have mercy. You guys are in on these comments. You Renee's like, look, I work in health and I still spell HIPAA wrong. Sue me. Sue me. I know. Listen, I was a not a pork. I was a poor grad student. I'm definitely going to be a very, very much poor law student if I attend. I mean, I'm just saying. I might start a YouTube channel just to grift for the tuition at this point. There's no way I'd be able to make it. There's no way. I need to have a lot of scholarships. Rebecca's like pork. All right. Exactly. Just a dose of morphine and muscle relaxer isn't going to kill this baby. It's just, but maybe that is an argument. I'm not a medical expert, so that is probably an argument that they're going to have in court, right? I'm just saying. I'm just saying. Yeah, I know. I'm going to grift for tuition. You think I won't? I will. I will document the journey so I can grift for tuition. Anyways, let me stop. Let me stop. Okay. Let's keep reading. So, law enforcement purposes, a covered entity may disclose to a law enforcement official protected health information that the covered entity believes in good faith constitutes evidence of criminal conduct that occurs on the premises of the covered entity. So, this is what the state is saying. They're saying, listen, there is no HIPAA violation here for there to be a dismissal of anything. Nice try. Do it again. Nice try. Thank you for pulling straws. In the present case, a homicide involving the abuse and the abandonment of a newborn occurred on the premise of the hospital. Providers were entitled to disclose protected health information that constituted evidence of that crime on the premises of that covered entity. The police department were called to the hospital for after hospital staff found a deceased newborn in the trash can in the bathroom. Upon arrival, they spoke with the charge nurse and the attending physician, who stated that the officers that a pregnancy test was done on the defendant and patient, and the defendant went into the bathroom, was in the bathroom for a while, and when the defendant came out of the bathroom, there was a lot of blood everywhere. So more exams were done on the defendant. After informing the defendant that the newborn was found deceased, law enforcement then began to gather the name of all hospital staff that had some involvement or contact with the defendant and therefore may have had relevant information to the anticipant criminal investigation. L. Lewis describes the condition of the bathroom, described how the trash can liners were placed in the trash can, and described that the trash can liner felt heavy when she was going, to change the liner in the trash can. She also described that she did what she did when she found the newborn. Let me reread that again. She also described what she did when she found the newborn. At no time in her initial interview with the police department on January 27 or her follow-up interview on April 2023 did she violate HIPAA by disclosing any protected health information. Additionally, custodians are not covered by HIPAA. Ooh, ooh, ooh. Did you hear that? They said the custodians, they're not the treaty, they're just there. The cleaning lady, you guys remember that? That's right. She was traumatized. She was upset. Boom, says Rebecca. Is the custodian staff there treating this person? No, they're not. They're not. Read that again. I will read that again. Let me remove myself because they wrote it very nicely. They said, L. Lewis described the condition of the bathroom, described how the trash can liners were placed in the trash can, and described that the trash can liner felt heavy when she was going to change the liner in the trash can. She also described what she did when she found the newborn. At no time in her initial interview with the Artesian Police Department on January 27 or her follow-up interview on April 2023 did she violate HIPAA by disclosing any protected information. Additionally, custodians are not covered by HIPAA. Okay? There you go. Supported staff. They're not covered by HIPAA. That's what they're saying. Ooh. Layla says you don't need an OBGYN either. It is preferred to have them for backup. Yes, in case of surgery necessary. But usually you don't need one to catch a baby, especially a young healthy woman. Good point. Good point, love. That discovery would be horrible, right, Patricia? I mean, you imagine, people that are medical staff, just imagine that. Yes. So are we expecting, is the defense attorney expecting that cleaning staff is going to follow HIPAA? Like what? I mean, hey, like I said, he was reaching for the straws and the stars. Okay, let's keep going. The emergency room tech, CNA Lori, informed officers that she checked on the patient who had been in the bathroom for an extended period of time, called the hospital housekeeping staff when she saw that the bathroom needed to be cleaned. She informed officers that the defendant had a positive pregnancy test. Interesting. Lori told officers that when she found the newborn, she immediately took him to trauma 2, informed her supervisor, and called the police. She stated to officers she delivered the baby and threw it in the trash can. These were her personal observations, not information learned from treating the defendant. Okay, so that statement right there, we know that there might be, I don't know how 100% that statement is fact. But what the argument that the attorney is making is saying that she didn't disclose any personal information. She followed up by taking this baby to trauma 2. However, based on the body cam footage, we didn't see all of that play out there. But the argument that the district attorney is making is that there was no disclosure of personal information because she was doing what she had to do as a staff member to follow up on what needed to happen, to follow procedure, to be exact. Okay? Let's keep going. I think it's H. Halliday was the charge nurse on the night of the incident. He spoke to the officers several times throughout the evening as the events were happening, as the hospital was preparing the defendant to be transferred to another hospital with a higher level of care. During his initial interview, he told officers that the defendant admitted to the hospital with lower. Ooh, hold up. During his initial interview, he told officers that the defendant was admitted to the hospital with lower back pain, that a battery of tests was conducted on the defendant to include a pregnancy test, an ultrasound, and a vaginal exam. After the discovery of the newborn, he described that he saw the trash can and described that he ripped open the liner and that the newborn was in there. He described to the officers the conditions of the newborn and there was no signs of life. We saw the body cam footage. We didn't see him rip the. This hospital staff need to get their shit together because April, from what happened in January, did not look like we saw the body cam footage. There was no ripping of the trash can. Y'all remember that? We saw it. Did they rip the trash can open? No. We saw it. We saw that they did not rip the trash can. I feel like I'm going crazy as I'm reading this, but let me just keep reading. This is what they're saying that they did. So this is what the district attorney is describing, okay? The information that the charge nurse gave to officers during his initial interview was all information that could be disclosed to law enforcement. He provided the defendant chief complaint, date and time of the newborn, and the tests that were conducted on the defendant. Okay, this information was all relevant to the investigation of the crime that occurred at the hospital premises. When the officers were gathering information about the defendant, they asked for a sheet from one of the hospital staff. Out of an abundance of caution, the charge nurse told his employees to not give the officer the defendant's sheet, just to provide them with her name so as to not violate HIPAA, since they had not yet received a search warrant. Oh, interesting. So the charge nurse said, "Don't give to the officers the medical stuff, the chart, to not violate HIPAA until they have a search warrant." Interesting. Interesting. By telling the officer that they can not only be provided with the basic demographic info of the defendant so as to not to violate HIPAA, clearly indicates that the charge nurse was acting with due regard for his patient's private medical information, even though HIPAA disclosure exceptions would have permitted more comprehensive disclosure during a police investigation into a crime that had occurred on the hospital premises. That is interesting. That is interesting. Right. But what they're saying here is that the district attorney is making the argument is that once the crime had occurred, the HIPAA goes out the door. So the charge nurse didn't have to do all that. They could have just given her the information. They could have. They didn't need a search warrant based on the fact that the crime was already happening at that time. but he took extra precaution. Rabbit cops don't come until after the fact. Yes. Yes. Gotcha. Gotcha, Marlene. Okay, so that's interesting. They didn't do a vaginal exam, did they? Would they have seen that she was dilated? Right, right. This is what I'm like, it's so confusing, but this is from the perspective of the district attorney's office, who's basically reviewing the reports that others have already done, I guess. Sorry, guys, give me one sec. I'm chewing on ice and drinking water. Thank you. Um, SL says, as a nurse, I would have done the same thing. Got to protect your license, right? But they did, right. It sounds like they were like trying to help out and not give out too much information to protect the disclosure. So the violation didn't happen by the hospital staff. And I wonder how much are they going to use some of this, what is being written for the civil case as well, for the wrongful death lawsuit. Okay. On April 20th, as the police department was still investigating the events of January 27th, Dr. Vasquez, let me see, was interviewed. She described to detectives the basic labs that were run on the defendant, and they received a positive pregnancy test from the urine test. Another test was run to determine more information about the pregnancy, which is known as a quantitative HCG test. She discussed the type of injury that the defendant had after coming out of the bathroom. What? She discussed the type of injury that the defendant had after coming out of the bathroom and what she did when she learned the news and other staffs had found a newborn baby in the trash can liner. Okay. The information that Dr. Vasquez gave to officers also falls under what can be disclosed to law enforcement without a search warrant. Gotcha. All right. Detectives from the police department obtained a search warrant on May 10th, 2023, which was signed by Judge Foster of the Magistrate Court. Included for the application for the search warrant was an affidavit of the events that occurred January 26th and 27th at the hospital. And a search and the warrant is for the defendant's DNA and other biological samples. No DNA tissue, no DNA tissue, blood, urine, or other biological samples of the defendant were obtained from the defendant by the police on the night of January 26 and 27. Thus, there is no violation of 45 CFR. So another ruling. Okay. Even assuming what is it? Is it argumento? Ooh, is that a Latin word? Hold up. Let me look that up. Argumento. It's Latin. Okay. So even assuming for the sake of the argument, that's what they're writing down. I had to look that up real quick. Even assuming for the sake of the argument that there had been a violation of HIPAA, the remedy would not be would not be suppression of the evidence obtained as a result. HIPAA itself does not provide that medical information so obtained must be suppressed. The court is unaware of any authority which compiles the suppression of the records obtained in violation of HIPAA. All right, so they're listing a source. Therefore, the alleged HIPAA violation would not warrant suppression of evidence at all trial, even if they had it occurred. Interesting. Defendant waived any privilege conferred on her by New Mexico rule of evidence. The defendant's argument that her statement to medical providers are privileged pursuant NMH should fail because the defendant waived any privilege conferred upon her by this rule of evidence, even by her. Hold up. Because the defendant waived any privilege conferred upon her by this rule of evidence when she spoke with the physicians in the presence of the officers. Interesting. The New Mexico Court of Appeals recently had the opportunity to consider this very issue. Another case cited. In that case, the Court of Appeals addressed the question of under what circumstances does the presence of a third party able to overhear a communication between a physician and a patient negate the privilege? You know what is so interesting is that they're not really talking about the mother, right? Because why aren't they saying, wouldn't that be, I mean, I guess if she agreed for her mother to have been present, that's not a HIPAA violation. None of that is a HIPAA violation. I guess I'm just wondering because there's a lot going on while mom is present. In Lucero, the defendant was involved in a motor vehicle collision. Law enforcement arrived on the scene and extricated the defendant from their burning vehicle. When the ambulance arrived, the defendant received emergency medical care from EMS in the ambulance, and the law enforcement entered the ambulance from the side door. Okay, they're just making the argument of why this applies to that. Let me skip over to the next paragraph real quick. The Court of Appeals decided the issue of whether the defendant waived physician patient privilege turned on whether the defendant actually knew the law enforcement officer was present when they made the incriminating statement. Okay. um, so they are defining confidential communication as a communication is confidential if not intended to be disclosed to third person or other or to third persons other than those present to further the interests of the patient in the consultation, examination, or interview, or persons reasonably necessary for the transmission of communication, or persons who are participating in the diagnosis and treatment under the direction of a physician or psychotherapist, including members of the patient's family. In determining whether the patient intended the communication to be privileged, the Court of Appeals ruled that if a patient is told their communication with the doctor or therapist will be disclosed to a third party and the patient voluntarily proceeds with the consultation with that knowledge, they will be considered to have consent or voluntary disclosure. The patient having voluntary consent to the information disclosed by their conduct cannot claim the privilege. All right. So she's citing this whole case as to why the communication is privileged. Let me see. Let me go a little bit down further. The Court of Appeals of Lucero analyze leads to the conclusion that a defendant waived privilege when she made a statement to her physician knowing that law enforcement officers were present in the room. The defendant was in the room with the officers from the Artesian Police Department, attending physician, the charge nurse, the defendant's mother, at which time was attending the physician was at which time the attending physician told the defendant about the newborn baby and what the next steps in the medical treatment would be. After learning of the news that the newborn was deceased, the defendant made the comment, "I'm sorry, it came out of me. I didn't know what to do." Okay. It is clear to the defendant that law enforcement officers were in the room. The defendant's own Miranda argument demonstrated that she knew law enforcement was present. Thus, under New Mexican law, the defendant waived whatever patient privilege communication had conferred upon her, even assuming the argument that the defendant, excuse me, 1 second. Yes, sorry, 1 second. Even assuming that the defendant did not know that law enforcement was present, her statement cannot be considered a statement for the purposes of diagnosis or treatment. The defendant's apology and statement did not concern the course of her own treatment or the deceased newborn. Ooh, okay. Hold up. Defendant's statements regarding the details of her abuse and abandonment of a child are not protected by physician-patient privilege. I think that goes and falls into the whole mandated reporter. They can't assume. That's right, Deborah. They can't assume. That's right. Furthermore, an exception to the doctor-patient privilege shall apply for confidential communication concerning any material that a physician, psychotherapist, or state or nationally licensed mental health therapist or patient is required by law to report to a public employee or public agency. Yeah, that's that mandated reporter information right there. So none of this is privilege, especially when you make a statement like that. Thank you, SW. And by the way, we're just giving commentary. We are not trying to solve a crime. I am a true crime commentary channel. I am not trying to solve a crime. All right. Thank you for putting that out there. Um, so they're giving the information as far as like the 1990 privilege exception for the court when that stops. Like, when is it that somebody becomes a mandated reporter? At that time, physicians in New Mexico are mandated reporters, as I just said. Thus, they are required to report child abuse and neglect statements made to them by a child abuser, and they enjoy no privilege. So if a parent says, I wish I didn't mean to bury Johnny, just saying, or Johnny just stopped breathing, that's kind of like, all right, that the privileged communication does not apply to that. Everybody that's a mandated reporter knows that. Keep that in mind. The defendant's Miranda rights were not violated because she was neither in custody nor interrogated with the investigative intent by law enforcement. Yeah, the body cam footage, she wasn't investigated, she wasn't interrogated. I don't even think they really asked her any questions about what happened as far as law enforcement. We could see that in the body cam footage. It is well settled that under the United States Constitution of New Mexico, that suspects have the right to remain silent and be free from self-incrimination. Right? Miranda versus Arizona. Okay. Let me keep going. Interrogation is defined by the United States Supreme Court as an officer asking the defendant questions that the officer reasonably should have known that elicit incriminating response. Here, the defendant was not in custody and made statements without any prompt from law enforcement. The defendant was in the treatment room with her mother. The defendant was not in handcuffs. The defendant had not been searched, and the defendant had not been told she was free to leave. Interesting. That she was, yeah, I mean, they didn't tell her she was not been free to leave. The defendant had not been told she was free to leave. Okay. In fact, law enforcement did not ask her any questions. I didn't see that in the body cam footage. We didn't see her being asked any questions. So I definitely agree with that. The defendant's physician entered the treatment and informed the defendant that we discovered a dead baby in the bathroom. The defendant immediately replied, "I'm sorry. It came out of me. I didn't know what to do." And that we did here. At this point, the attending physician informed the defendant that she will be airlifted for further care. Shortly after, law enforcement informed the defendant that she is detained, but refrained from asking her any questions. The defendant's mother began asking her daughter questions about her disposal of the baby, at which point the officer asked her to stop. I remember that. Okay? I remember that. The defendant was not asked questions by anyone with investigative intent after she was informed she was being detained. Officers went so far as to ask the defendant's own mother to refrain from questioning her until detectives could ensure she understood her rights before she was subjected to any further questioning or functional equivalent questioning at and at all times. The defendant's Miranda rights were scrupulously honored. Therefore, there is no basis upon her statements should be suppressed. Okay. SW says, FYI, 2 milligram dose of morphine would have been the starting dose. It would have relaxed her delivery to the baby, not to affect her right and wrong choices. Thank you for the $5. Interesting. Thank you, SW. Deborah says, I don't feel for her so-called mom in this case. She does need to be punished for what she did. It was so wrong, and I'm a true believer in HIPAA. Thank you, Deborah. So you, Deborah, do you feel like HIPAA was violated here? I mean, um the attorney is making the argument that HIPAA was not violated. It sounds like she spoke. Yeah, she spoke under her own violation when she said, "It came out of me. I'm sorry. I didn't know what to do." I don't want to air quotes. I don't really know what her direct statement was. Give me one sec. Patricia says, um, "That does get to me. That no one asked about how the child was doing." Right, right, Patricia. Very little questions about how the baby was doing. I mean, I guess if she assumed, well, the baby came out dead, there wasn't a whole lot of questionings overall about, okay, like, how did this happen? I don't know. I get, I don't know, but I hear what you're saying. Defendant's demand for Pena versus Espinosa procedure determination is premature. Defense motion states that the court should conduct an in-camera review of the defendant's relevant medical records as to comply with privacy rights of the defendant and to not violate. The court, the New Mexico Court of Appeals, while we agree that an in-camera inspection has its place in the scheme, um, we believe that the immediate resort in-camera inspection would unduly burden the trial court and would deny the opponent of the privilege the opportunity to test the claims of privilege through the adversarial process. Okay, and let me go down a little bit. The party asserting the privilege bears the burden of establishing that the privilege applies because Rule 11504 speaks in terms of privileged communication, not privileged document. The party asserting the privilege, the defendant in this case, must assert the physician patient privilege with sufficient details so that the state, ultimately the trial court, may assess the claim of privilege to each withheld communication. The defendant has made no such showing, and as such, their demand for an in camera review is premature and should be denied on the stages of this proceeding. Wow. Conclusion. Therefore, the state of New Mexico thereby prays that this honorable court to deny the defense motion to suppress based on alleged HIPAA violations, claim of HIPAA or other unspecified misconduct. Unlike the defendant has not met their burden for the court to hold Pena and Espinosa procedures determination. Finally, the state takes no position on the insurance of protected order related to the defendant's medical records. This was 13 pages. Okay, and this was the state's motion to suppress. We're going to go to another one that was also released today. There's a lot that was released. This is crazy. This is like, it's getting pretty interesting. It's getting interesting. Hold up. Let me see, because I have too many. Let me close that out. Okay, state response to DEVYN. That's what we're going to be reading. Is it this one? I think so. Yes. State's response to DEVYN. Here it is. And again, this is from At the 10th Woman. I'm going to put their social media handle in the description box so you guys can check them out. And it says State of New Mexico's response to defendant's motion to reconsider conditions of release. Comes now the state of New Mexico by through the district attorney Diana Luce, and hereby requests this courts deny defendants above titled motion. In support of its request, the state submits the following. Let me see how many pages. Okay, this is only 6 pages. It shouldn't be too bad. All right, this is going to be interesting. Wait until you hear this one, because I was reading a little bit of this one. The state incorporates by reference the argument, facts, and findings of both the pretrial detention hearing and preliminary hearing held in the matter. As the court is aware, the defendant is charged with first-degree murder and tampering with evidence for disposing of her newborn baby boy in the trash can in a restroom, or not a restroom, yes, excuse me, a restroom of hospital of a general hospital after she concealed the newborn in a trash can liner. The legal argument: the court should consider the nature of the circumstances of the charged offense, including whether the offense is a crime of violation, the weight of the evidence against the defendant, the history and characteristics of the defendant, the nature and the seriousness of the danger to any person or community that would be posed by the defendant in the absence of the condition of release designed to prevent such harm. The defendant's motion to reconsider her condition of release focuses entirely on her desire to continue a personal relationship with their boyfriend, whom she is currently forbidden from having dating or intimate relationship with. That is on paragraph, let's see. This is the one, two, three, third, fourth one. Because if you guys remember, we were reading those motions and they were saying from the defense, the boyfriend, they're going to go to the state college, they're going to go hang out, they need each other. Please fix this for their condition. They're going to be hanging out together. They're going to have contact. I'm drinking some, what is it? One of those little spray bottles in the water, flavor water thingy. It's tang, very tangy. Mm-mm-mm. I need some coffee, though. That's what I really need. Oh, man. Okay, so following the pretrial detention hearing, the Honorable Judge David wisely ordered that the defendant not have any personal contact with any person who is or could be defined as a continued person in the relationship. Exhibit A. This prohibits restricts the defendant from having a dating or intimate relationship. We talked about that. We said, who were they talking about? I do desire some coffee. I'll probably have some after this live. Who are they talking about? And we were like, does that include like Devyn, or is that the mother? Who is it exactly? You all remember when I asked that question? Because that would be Devyn if that's intimate relationship or dating. The last time the defendant engaged in such a relationship, the result was her disposing of a newborn baby in a hospital trash can where the baby ultimately died. This prohibition is designed specifically to mitigate the risk of the defendant's reoffending in such an egregious fashion while she's pending trial for first-degree murder. Ooh, this prosecutor. Oh my gosh. Oh my God. All right. Oh my goodness. I'm clutching my invisible pearls. Members, you guys have those invisible pearls in there? I'm clutching because I'm reading this and I'm like, OMG. OMG, period. She said, period. This is what happens when you have sex. You put babies in the trash can, but that's what they're saying. Period. Oh my goodness. Clutch, clutch, clutch. I can't. All right. We're almost done here. I promise. We're almost done. Okay. Despite the counseling the defendant claims to have engaged with, she nevertheless sees no harm in attending college with a man her counsel describes as her boyfriend. The fact that the defendant has a boyfriend at all is an apparent violation of her current condition of a release. The defendant seeks permission to continue this relationship with her boyfriend, attend the same college, spend time together in class on and off campus, and commute to and from school. The defendant's apparent disregard for her current conditions of release, evident by her continuing a relationship with her boyfriend, illustrates why the conditions of release prohibiting her from engaging in a dating or intimate relationship should remain in place. I am spitting everywhere. I'm clutching my pearls. That's wow. Wow. That Layla, because that was part of her conditions. She said, Layla, I'm a tad confused. Why don't they need them to be together? If she was the one who tossed the newborn baby into the trash can and wasn't physically at the hospital, was he even aware that she was pregnant? That's a good question. That was my question. Did he know that she was pregnant? You know? But the thing is, so I can understand if he's going to testify against her, why they shouldn't be together. What if he's a witness? What if he's gonna be made to testify? If he's gonna be made to testify, then yeah, like you probably don't want them to have contact. That's kind of what I'm wondering. But clearly they're still together. They're going to college. And here's the thing. Isn't there something called online college? Like why can't she took some I took some online courses. Why can't she do courses online? She has to travel to New Mexico? She got a criminal case facing. Yo, you got to listen. Some of this is not making sense. You're calling the Uno card on this? No way. SW said Uno card. No way she didn't know. Fuck around and find out, right? Like this, I'm just wondering. I'm trying to be as it's a sugary drink, so I'm trying to let it get into the bloodstream, you know, just a little bit. Mm-mm-mm. Just a little bit. We're almost done. Sorry, I'm too nice now. Give me 1 sec. Let me mute myself. Let me finish. Okay. Let's keep reading because we're almost done here. All right. So the district attorney is saying the fact that she even has a boyfriend is a violation of the conditions of her probation. All right. She's not understanding that. Defendant's motion should be denied and her apparent violation of her current conditions of release should be addressed at the hearing requested by her counsel. The defendant's motion should be denied using the factor articulated on Rule 5-40C13. We don't need to read all that. The defendant's admissions, video evidence, and fact witness testimony demonstrate that a defendant's condition of release should not be modified to be less restricted as there is strong evidence against her. The charges are extremely violent and serious and include the use of the wanton violence against a helpless newborn baby and calculated concealment of her murder of that baby. Therefore, the state respectfully requests this court deny the defendant's motion to reconsider conditions of release, maintain the current conditions of release, and address the apparent violation of her current release. Respectfully, ooh, Diana's not playing. Look at this. And this is the paperwork. And this is where we're talking about. Remember, we talked about this. Not to have any personal contact. It is this violation right here. And let me pull that short up because I know I did a short on this on my channel 2 months ago. We talked about this. Hold up. Where was it at? Where was it at? I've done a lot of shorts in the last couple of weeks. Was it this one? Hold up. Hold up. Hold up. Wait a minute. Was it this one? We're going to pull that up right now. Here it is. It's right here. And she attached the conditions. This is the one I'm talking about right here. We did this like 2 months ago. Watch this.
This document, the order setting conditions release. We talked about the bond and everything. I want to go to an area where we had some questions about who the court could be talking about in this part. Right here, where it says defendant's conditions of release. Other conditions, not to have any personal contact with a person who is or could be defined as a continued personal relationship under 30-3 11B. So I looked that up to kind of get some more perspective. B is listed as continuing personal relationship, means dating or intimate relationship. Is it possible that Alexee isn't able to have contact with Deyvn as of this order, as of conditions to her release? Potentially. I'm curious. Let me know your thoughts.
I called it, didn't I? So if they've been having contact, that has been a clear violation of that order, the conditions that were set out there. I knew, I was wondering. I said, who are they talking about? Who are they talking about? And people were saying in my comments, no, they think it's the mama. No, it was not the mama. It was not the mama. It was Deyvn they were referring to. Just saying, we called it out. We called it out like 2 months ago. Yes. I'm surprised they didn't put her on something. On something. I'm just saying. I just kind of like wondered. So she's adding this in there to further highlight. And I looked that up. That's what they signed. They say you are not to have contact. So why would they approve anything at this point? Why would they do that? Why would they do that? It just what she and I hate to say it, like we don't know if he's going to be a witness. He might be called to be a witness to this. We don't know anything, right? So if that is the case, they should not be having contact at this time, regardless if she's starting school or whatever. That's not the point. You're facing a murder charge, okay? That is a huge thing. She should not be having contact. She shouldn't even be thinking at this point. What she needs to do is sit down. Now, this is me being say, sit down and possibly think about online schooling until she can go to trial next year, because that's really when the trial is set up for next year. The last thing you should be thinking about is going to, dorms and all that other stuff, because it's even calling attention to the university as well. Mind you, this is allegedly, I heard that she had this roommate. She was set up to have a roommate somewhere in New Mexico while she was going to attend this college, and the roommate found out who she was and immediately said, fuck no, I don't want a roommate with you. That's what she said. She said, no, I don't want a roommate with you. So she posted bond. She's released. She needs to sit down somewhere and figure this out before she goes out there. Before she needs to face the trial, she needs to face the music. That's where I stand. The audacity on top of the audacity. Shout out to that district attorney for saying you're violating this. And the fact that this isn't even a motion to change the restriction, it's the knowledge. That attorney knows she can't be having contact with him. That attorney knows that. I knew it, and I read a little essay. They got to be referring to Deyvn on this one. Makes me wonder, have y'all been having contact? Thank you. Thank you. I'm just saying. I can't be the only one that noticed that. I'm just saying. That's crazy. That is crazy. So that is the breaking news. We have 2 new motions from the district attorney's office, and they said there was no HIPAA violation. There was nobody violated her rights. The police officers didn't. The hospital didn't. No violations occurred. Okay, keep that in mind. This new motion here to say whether she can attend college with Deyvn and have this contact, nope. These are new motions. Shout out to everybody in the chat. I hope you guys have a great one. I will see you guys later on because I got to go tend to a little baby bunny. Shout out to my beautiful, wonderful mods and my members. Thank you guys. I will see you guys on the next one because I got to go tend to that little baby bunny. Rabbit tail.